Good morning. Welcome to the Illinois Small Business Development Center at Rockford Chambers virtual classroom. I'll just introduce who we have on the call today. We have Edward Caceres, our director, and Mike Mastriani, our business consultant.
Hello.
So for today, we're going to go ahead and start with our speaker. Our speaker today is Samuel Castry, Senior Vice President and General Counsel with Staff Management. And Sam is going to talk about legal issues with small businesses today. And with that, I will hand it over to you, Sam.
Great, Heather, thanks very much. And welcome to everybody. I know we've got quite a bit of information, so I think we'll just dive right in to the materials here today. When Edward and I first talked, we had talked about what's the topic, and he came up with like more of a COVID-related one, and I suggested something else, and that was some common employment law mistakes to avoid. But truth in advertising, some of that information didn't immediately get uploaded to the website. So some of you may be thinking, oh, this is all going to be COVID related. We got some of the information changed, the title never changed. And so even with the new information, you still might think this is COVID related. So when I noticed that last night, when I got the link to the presentation, I said, oh my gosh, I've got nothing COVID related. So I have certainly added some COVID related issues to the end of the presentation. So everyone will be happy or everyone will be upset, one or the other. But this is primarily what we're going to talk about today. And the many employment law issues facing startups and ongoing businesses, obviously. We do a lot of HR audits for organizations. I see some very common mistakes. Mistakes, certainly when you're starting to build your business, if you get these mistakes built into your foundation, you're just going to have problems down the road. So here are some important issues, I think, to address and try not to make these mistakes so we have a better business situation going forward. And certainly issue number one, hey, I'm too small, I'm a startup, I don't have to worry about this employment law nonsense. And needless to say, there's an entire alphabet soup of employment law regulations, and you are never too small. You have one employee, you are covered by many laws. And certainly as you grow, there are different thresholds. You may become covered by more laws, but you are never too small. And so certainly some things of general application, unemployment, workers' comp, Illinois Human Rights Act, payroll taxes, et cetera. Even with just a handful of employees, you're covered by those things. And as you grow and hit other thresholds of 15 or more employees, more civil rights laws kick in, or at 20, COBRA and more civil rights laws kick in, and then 50 leave laws, and on and on and on. So you're never too small, and throughout the life of your organization, you're going to have to address these issues. Here's a big issue we run into very frequently. I pay my employee a salary, I don't have to worry about paying that employee overtime. And that is a huge myth and a huge mistake. And the clear answer is no. And paying someone a salary is part of the issue, but it's not the only part. For an employee to be exempt, meaning they're exempt from overtime, I don't have to pay overtime for hours worked over 40 in the work week. I have to not only meet that salary test, but also like what's called a duties test. The salary piece first, it's a guaranteed salary, not subject to change regardless of quantity or quality of work. Currently, that's $684 a week. That's the easy part. That's the salary basis. The harder part, and the part where we see mistakes frequently, is this duties test. And we're going to tackle this very briefly, but you have to fall into one of three categories. One, an executive or managerial, meaning I supervise the work of 2 or more full-time equivalent employees, and I have the authority to hire and fire those individuals, set some terms and conditions of employment, or if I don't have ultimate authority, I can make recommendations that are typically followed. That's pretty easy. Professional is pretty easy. It's a long course extended specialized study, so doctors, lawyers, some could be engineers, accountants, a specific degree requirement, not a general degree, but a specific degree requirement in that sort of things, again, pretty simple. Administrative is where we get into problems. So no, your receptionist, your administrative assistant probably is not exempt. And while they do some office or non-manual work, which is related to business operations, that's going to be true for most administrative employees. The key here is that I have authority over important matters. I have discretion and independent judgment. Typically, we don't find that in some lower level administrative situations. So that's, again, very briefly, but be careful. Just because someone's paid a salary does not mean you might not have to pay them overtime. Next issue we see quite frequently, I can give my non-exempt employees some comp time in lieu of overtime. We want to control our expenses. I don't want to pay someone overtime. So I'll just give them some comp time, some time off instead of overtime. So like an additional vacation or some additional personal leave or whatever it might be. And the answer then again is no. Now, public sector employers can do this, but private sector's employer really can't. You can manage your workforce. So if you do have at least a biweekly payroll, you can always tell people when to come to work and when not to come to work. So if someone works, let's say 2 hours of overtime in week 1 of your 2-week payroll cycle, then certainly the next week you say, yeah, take some time off so you can balance your overtime. You are in fact paying that person 2 hours of overtime in week 1. But in week 2, if you tell them to take some time off, it'll work out the same. That time off has to be a time and a half. So if I work 2 hours of overtime in week 1, I've got to take 3 hours off in week 2, and it all nets out, it pays the same. What you can't do is say, well, we'll just bank that time. We'll carry it over from work week to work week, from month to month, et cetera. That will not work. That's a violation of Fair Labor Standards Act and Illinois minimum wage law. So you can certainly balance overtime and tell people when to come to work and when not to come to work, but you can't have this comp time bank that violates our wage and hour laws. And again, pretty common mistake we see. You'll see this is another wage and hour issue. Wage and hour issues, I think, are some of the most common. We see certainly a lot of litigation there over the last probably 15 to 20 years. As plaintiffs' attorneys said, wow, employers always mess up wage and hour issues. We can get attorney's fees under these statutes. Let's look at this. So another one issue we see typically is docking an exempt employee salary for a partial day absence. So again, your exempt employee, that person is paid a salary that's an administrative, professional, executive employee, and maybe they miss part of a day because of whatever reason, personal reasons, illness, et cetera. And you say, okay, because you didn't work half a day, I'm going to dock you half a day of pay. You can't do that. Again, going back to what is being paid on a salary basis. It's being paid a guaranteed salary, regardless of quantity or quality of work. So if I work more than 40 or less than 40, doesn't matter. I get that guaranteed salary without deduction. Now, there are a handful of exceptions, of course. But partial day absences are never okay. If I work part of a work day, I come into work for a half hour. All of a sudden, I realize I'm coming down with the flu or something, and I go home. Guess what? I have to get paid for that entire day. You can certainly require someone to use a sick pay bank or a personal pay bank. But if they run out of that and have no other paid time off available, you're going to have to pay them for that full day, even though they only worked part of a day. So be very careful in general with docking an exempt employee. You run the risk that they will not be treated as an exempt employee, and all of a sudden you're responsible for lots of overtime perhaps. So be careful with that one. So yes, no, to meet it, you can't make that deduction. Another very common issue. I can prohibit my employees from discussing or disclosing pay information. I don't want them to know about what the other person's making. And that's wrong on at least a handful of accounts. One, no, you can't do that. It may be frustrating, may be aggravating, whatever feelings that might get you going. No, you can't do that. And one is the National Labor Relations Act. And you might think, well, I don't have a union in my workplace, and that does not matter. The National Labor Relations Act protects employees, even if there's not a union. And if they engage in what's called, concerted activities, certain protected concerted activities, then we can't take action against them, even if there's not a union. So what's a protected activity? Well, it's something regarding terms and conditions of employment, wages, benefits, hours of work, working conditions, those types of things. It's concerned when it is at least two employees or one employee acting on or representing other employees. So if two employees want to say, how much do you make? Oh, no, I don't know, how much do you make? That's regarding wages, terms and conditions of employment. It's a concerted activity. There are two people. We can't tell them not to do that. If we did, it'd be an unfair labor practice. Secondly, it's also a violation of the Illinois Equal Pay Act, and this is more recent from 2019. There was an amendment to that act back in September of 2019. It also said you couldn't ask people for prior wage information, and as part of that, they said it's a violation if you try and restrict current employees from disclosing or discussing their own wages. So we can't do it based on that. There are certainly, in addition, under the Biden administration, there are certain bills before Congress, and that would become, if that bill were ever passed and signed by the president, there are some bills that have similar language regarding this restriction. So we can't require employees not to talk about their wages. Another very common one, vacation pay. And someone doesn't give you 2 weeks notice, or if they've made mistakes, or you don't like them, or whatever reason, right? They quit without notice, terminated for misconduct. You say, I'm not going to pay that person the balance of their vacation pay. Or I'm not going to pay them the balance of their vacation pay until they return some piece of property, those sorts of things. Unfortunately, those are all wrong. Upon termination of employment for any reason, misconduct, good reason, bad reason, no reason, someone quits, you have to pay out all earned but unused vacation pay. And back in the day, not that many years ago, there really weren't a whole lot of teeth to the Wage Payment and Collection Act. And basically, if you didn't do it, but the Department of Labor got involved, finally say, okay, fine, I'll pay them, that employee. Now there have really been some teeth to that statute. And if you're a business owner, not only is your business liable, you're looking at personal liability to pay that amount. There are penalties and fines, et cetera. So it's really it's become a bigger deal not to pay this out. And again, there really aren't any exceptions, whether you like the person or not, whether they gave notice or not, whether they've returned property or not, et cetera. You're going to have to pay out whatever that vacation balance is upon termination. Oops, sorry. I-9 forms. I'm kind of shocked. This I-9 form has been around since 1986. And yet when we work with small businesses and some that even been around for decades, they say, I'm sorry, what's an I-9 form? We don't do that. And then I pick my jaw up off the floor and say, oh, well, it's that form that an employee has to fill out that shows that they're eligible to work in the United States. And they, I don't do that. Other employers do it, but do it, frankly, rather poorly. And we're constantly finding errors when we do audits of I-9 forms. So employers, you have to verify that all employees are legally eligible to work in the United States. And again, that's accomplished through that I-9 form. What are some common mistakes that we see? The employee has to fill out section 1, which is their portion of that form, on or before that first day of employment. So if they fill it out 2 or 3 days after employment, mistake, error, could be fined for that, too late, right? Employers, then you have 3 work days, 72 hours, to fill out, complete the form, okay? And that's, and if you may be familiar with that, that's when someone has to provide you with some documentation, such as very typically a driver's license and a social security card, or a driver's license and a birth certificate, or perhaps a passport, those types of things. And then you do have 3 days from the start of work. We often see that someone started work and this is getting filled out by the employer days and weeks late. That's often a problem. We see sometimes in orientation materials, provide us with your driver's license and social security card to complete the I-9 form. No, that's another mistake. You can't request specific documents. You can't reject documents someone gives you as long as on the face they look legitimate. Someone hands you a permanent resident alien card. You can't say, oh, I don't want to see that. Give me your driver's license and social. Can't do that. Again, that's a violation.
And can they keep copies? Do employers keep copies of these now, or just look at them and verify that they've seen them?
Either way is appropriate. You don't have to make copies of these things. Some employers do that to make sure that they've got that. The only caveat there is if you do make photocopies or some other digital copies of these documents, you have to do it for everyone. You can't say, well, we're just going to do it for the people that provide us with a permanent resident alien card. We'll copy those. No, that would be a violation. So you can make copies, but you have to do it for all employees. And that's okay. And if you don't, what do we look at? Well, violations can run from $110 to up to $1,100 for repeated violations. So it can get kind of expensive. So take some time to do that and try and do it correctly. Sexual harassment training is unimportant. I think we know a little bit more now since the Me Too movement and going back several years that this isn't the case. And yet sometimes I still, when we talk to clients, we see that as a problem. And it used to be before, it was just a really good idea to conduct some sexual harassment training. You'll see encouraged it, said it was the best practice. You could use that as a way to frankly limit liability if problems did come up later. Since then, however, I mean, not only is it a good idea, now it's in Illinois anyway, it's a mandatorily good idea. And since January 1 of 2020, annual harassment training is mandatory in the state of Illinois. And that, due to some other amendments to the Illinois Human Rights Act, applies to employers of one employee or more. So even if you have just one employee, you have to make sure that that employee annually has sexual harassment training. And that harassment training has to cover certain topics. And we've worked to some clients say, oh, I read them my sexual harassment policy. That's my training. I'm glad you're doing something, but that's probably not enough. There are certain topics that have to be addressed. There are certain, people that can provide training. There are online things. And at least if you went to the Illinois Department of Human Rights website and went to their training tab, they have a PowerPoint presentation for sexual harassment training. To be honest, it's 36 slides. It will check the box. You can say, I fulfilled my training responsibilities. I'm not sure it's going to train culture. If you've got issues in the workplace, it's probably not going to do that. And if you don't, then maybe that's fine. There's certain ways you can address it, but make sure at least that you do it, because even now, occasionally we run into employers that say, well, I didn't know we had to do that, and, but it has been a requirement now for over a year. And I think a lot of times say, well, this is aggravating, especially for small business. You know what? It's a big hassle. I don't want to mess with this stuff. So I'm just going to hire an independent contractor. We'll call them contractors. And sometimes that works, but there's been really a big emphasis, perhaps more so prior to the Trump administration, but now I suspect with the Biden administration as well, an emphasis on misclassification of individuals as contractors instead of employees. And there's a push to have those individuals treated as employees. Now, different employment laws have different tests. The Illinois Unemployment Compensation Law has one test. Fair Labor Standards Act has, frankly, a different test. Internal Revenue Code issues for employment law taxes has a slightly different test. There are some commonalities. We won't go through all of those. But frankly, I just said, as a practical matter, can they pass what I call the plumber test, right? Think of if you were to hire a plumber, that person is probably going to be an independent contractor, unless you're a plumbing contractor, right? What are some of those factors when you hire a plumber? Do you direct or control how the plumber performs his tasks? No. You say, hey, my faucet's leaking, please fix it. So what happens? He fixes it. And you don't tell him how to do it. He'll charge you triple. He knows what equipment to use. He knows what tools to use. He knows what, that sort of thing. And he does it. You don't really control that work. You probably don't have an ongoing relationship with the plumber, hopefully, right? Because your pipes aren't leaking all the time. Ongoing relationships is typically with an employee, right? Controlling how someone does their work, when to show up, how to do it, when to do it. That's what happens with employees. Is that individual really integrated into your business? And does their performance really affect the success or failure of your business? Probably not. A plumber, he kind of comes in, does his work and leaves. But employees, yes, they're integrated into your operations. The success of your business may very well depend on that individual's performance. Does that individual work only for you? That individual is probably employed. The plumber works for lots of different people, right? Who provides tools and equipment? Well, the plumber provides his own tools and equipment, right? But employers typically are providing tools, equipment, office space, et cetera, for employees. And in general, does that person hold themselves out to the public to provide the service? So a plumber probably has, back in the old days, ancient times, a yellow page ad, something like that, but now probably a website, or at least some sort of web presence or social media presence, and advertising their business. Might have, business cards, marketing materials, et cetera. Employee typically doesn't have those things. And so those are some of the factors you need to look at. But again, there's a lot of emphasis. There certainly was right after the Great Recession. Why? Tax revenues are down for unemployment, for Social Security, et cetera, and a lot of emphasis on state agencies to address this issue. I suspect it'll happen again. So be careful on how you treat individuals, because the burden is on you as an employer. The assumption is that person's an employee. Now you have to prove, no, he's not, no, she's not. And finally, for quickly hit some of the COVID issues. Hey, my employees are at will. I don't need a reason to fire anybody. So I'm just going to get rid of this person. Is there employment at will in Illinois? The answer is yes. And what is that? Well, employment at will means as long as I haven't hired you for a specific term, so I don't say you've got a year contract, something like that. Most of us don't have that. That I can terminate you for any reason at all, a good reason, bad reason, no reason at all, with or without notice. You're wearing an orange and blue tie. I don't like orange and blue ties. You're fired. Perfectly legal. The problem is there's been such an erosion to that employment at will doctrine. There's so many reasons why we can't fire someone. And just looking at our civil rights laws, we can't fire someone because of race, gender, national origin, age over 40, disability, religion, and on, that it's really a much better practice. Let's have a reason why we're terminating someone. If it's a performance issue, let's have that documented. Let's have communicated that to the employee so they know why they're getting terminated, so we can be consistent in how we handle these things. So just relying on the shield of employment will is kind of a flimsy shield, so be careful. Now, for those of you who are expecting more on COVID, let's talk about a few quick issues here as we wrap up things. So what are some of those legal challenges facing businesses in the aftermath of COVID? I'm going to focus in particular on some of those employment law issues. I think number one is, to vaccinate or not to vaccinate. Some employers are considering requiring their employees to get vaccinated. And the question, well, can I do that? Now, there's some more nuance to this, but the brief answer is yes, you can require employees to be vaccinated. There are, of course, exceptions. One is if someone has a disability, perhaps it's not medically recommended that they get the vaccine. You, under the Americans with Disabilities Act or under the Illinois Human Rights Act, will have to consider a reasonable accommodation to that person's request of whether or not they have to get the vaccine. So that is one issue. People may also decline based on religious reasons. And again, you as an employer have an obligation to consider a reasonable accommodation based on someone's religious preferences. So the short answer is yes, you can require it, but you may have to address accommodation issues. Now, again, this is the very brief description. There is some more nuance to that, but the general answer is yes, subject to reasonable accommodation issues. What if I'm not required, but I kind of want to know if someone's been vaccinated, because I want to know perhaps if I still have people working remotely, or what risks are if people aren't vaccinated. Can I request proof of vaccination? And the answer there, again, is kind of a yes, but to just ask, have you been vaccinated, or can you provide me with proof of vaccination, is okay. And someone can respond yes or no, or whatever the case may be. What we can't do, however, is really do anything beyond that. And if we start asking questions about, well, why aren't you vaccinated? Or how come you've decided not to get vaccinated? Those types of questions. The problem there is we again run into issues with the Americans with Disabilities Act or the Illinois Human Rights Act, and some of those become medical inquiries that might otherwise be prohibited. So just to say or ask, are you vaccinated, or can you provide me with proof of vaccination? That's okay. But don't ask any follow-up questions. They're really primarily off limits. And even if a person says, well, I'm not getting vaccinated and it's because of this particular health, and you don't need to know that, don't need to know any health issues, just want to know if you're vaccinated. Don't kind of shut it down, or if they do kind of blurt something out, that's fine. They've opened a door, you can't walk through, just close it figuratively here and say, okay, fine, thanks. I just wanted to know, I just need to know if you're vaccinated. It'll help us know when we can bring people back, or what other safety precautions, et cetera, we might need to take. OSHA obviously is still an issue. I know all employers required to provide a safe workplace for employees. OSHA has been active and getting a little bit more active in how they are addressing COVID issues in the workplace. Just this past March, OSHA published its updated interim enforcement response plan for coronavirus disease. What does that say? Well, basically, it's going to look to those organizations, those businesses where there have been, fatalities are related to COVID, multiple hospitalizations or outbreaks of COVID in the workplace. And those are going to be the industries or the particular work sites that are be under great scrutiny. What can you do to protect yourself or protect your employees as well as your organization? And really, even in that enforcement plan, OSHA just really reemphasizes, continue those good social distancing and hygiene habits. Have people continue to wear masks, have people continue to be socially distant. Where possible, have people perhaps work remotely or have meetings such as this, Zoom or otherwise. Do your regular cleaning, although clearly the evidence is pointing that this is a air-based, airborne disease, more so that you're not going to catch it probably so much from touching things, but you still want to wash your hands. You still want to have soap available. You still want to do some regular cleaning, but it's more the social distancing and mask wearing that's going to probably be of the most benefit to employees. So that's the brief on OSHA. And finally, should I continue to offer emergency paid sick leave or emergency family medical leave? Under the Family First Coronavirus Response Act, was about a year ago, just a little over a year ago, when that went into effect, it created emergency paid sick leave and emergency family medical leave for employers of fewer than 500 employees. And as you may recall, if someone came down with COVID, had symptoms of COVID, was seeking treatment, if was taking care of someone with COVID, and they might be able to have emergency paid sick leave, emergency family medical leave if school was closed or daycare was closed. Someone might be able to qualify for emergency FMLA. That requirement ran through December 31st, and then it stopped. What happened after that, though, was one law under the Trump administration extended that and said, employer, if you may voluntarily continue to offer EFMLA and EPSL And if you do voluntarily continue to offer that, we will continue to allow you to take a credit against your payroll taxes to pay for it. Under the Biden administration, that was extended further. So this goes through September 30 of this year. The reasons for taking leave or emergency sick leave have expanded to include, someone's getting a vaccine, or if has had a reaction to the vaccine and becomes ill or needs some time off. That's another reason. All the reasons that were allowable for emergency paid sick leave now also qualify for emergency family medical leave. As of April 1, all employees, again, voluntarily, if you as an employer choose to do so, all employers can get a new 2 weeks worth of emergency paid sick leave. That is not the case with emergency family medical leave. That has always been a 12-week allotment. And if people have used some of it, then they just basically have whatever balance they may have left. If they use 10 weeks in 2020, maybe they've got 2 weeks now they can use through the end of September of this year. But again, the emergency sick leave, that is a fresh 2 weeks for everyone. Again, only if you as an employer decide to voluntarily allow it. What's the benefit to you as an employer? Well, I get it paid for basically by the government by taking, again, a credit on my payroll taxes. We're coming up on our 40 minutes, left a few minutes for questions, and wonder if anyone has any questions today on some of the materials we've discussed.
Okay, we'll open it up for questions. If anyone has any questions, you can unmute and ask a question.
I got a question, Sam. In the case of the restaurants, for example, that some employers, business owners are asking their employees to come back, and they say that, they prefer to get the vaccine first or anything before come back to work. The employers can hire another person temporary. In the meanwhile, these persons come back to take their positions, or how they can handle this? Because I got, for example, a couple of clients that their waitress seems like I don't want to come back, but they want that the owner keep the position for them. And the budget is kind of complicated to take that kind of decisions, and especially in the aftermath of COVID-19. So which could be your best advice for the business owners that are facing this? Okay, what I'm doing with it is, I understand that the employee is asking for some, safety because he's afraid about his health. So how they can handle this properly?
Right. That raises a couple of issues. One, does that waitress who's reluctant to come to work, does she have some sort of disability that might make her susceptible to disease? You might have to accommodate that potentially with some unpaid leave. For someone, whoever, who's just like, I don't have any pre-existing conditions, it just kind of makes me nervous, that's really not protected. And so you could say to that person, or someone's just reluctant because I'm making money on unemployment or whatever the case may be, they don't want to come back. You can say, no, I have a job available for you, I need you to come back. And if they say, well, I don't want to come back right now, then you could say, fine, I have to replace you because I need
someone in your position.
I need someone in the position. But again, I would at least consider, is there an Americans with Disabilities Act issue or a Illinois Human Rights Act issue that because of health reasons for not coming back. But there's still, even then, there are limits to how long an employer would have to keep the job open there. But in general, if someone's just reluctant for whatever reason and no particular health issues, you could say, sorry, no, you have to come back. If it's a long-term employee and you're willing to, provide a little extra time off till they can get vaccinated and fully vaccinated, that's kind of up to them how they want to address that issue. But in general, no, as long as there's not a disability issue, need you to come back. I'm not going to come back. Okay, fine. Well, I'm going to have to fill your position with somebody else.
Another question, Sam. Can you ask as a requirement to come back, to your position to be vaccinated? For example, in the case of manufacturing facilities, those that work with pharmaceutical divisions, for example, that of course, you are producing the medicine. The last thing that you want is, bottle the virus because someone is infected. So could be a requirement or could be legal if an employer, based on the kind of activity, require that employees before combating, especially now that basically in most of the state, everyone with 16 or more is able to take the vaccine. Could be illegal that, some employers, due to the kind of business that they performing, require that employees get vaccinated before come back?
Right. The short answer is yes, you can require an employee to be vaccinated prior to coming back to work. Again, with the caveat, as we discussed before, you might have to consider reasonable accommodation for individuals who have a disability or for people who have a religious objection to the vaccine. You'd have to go through that reasonable accommodation process and decide if you can accommodate it and then allow them to come back to work without the vaccine, or if somehow it causes an undue hardship to the organization, you might then, there's a lot to that decision, but at that point, if you come to the determination it's an undue hardship or they pose an undue risk to others, you could say, sorry, you can't come back. But you would have to go through that reasonable accommodation process for disability or religious reasons.
Sam, are employers at all protected in any special way from people claiming that they got COVID from work, or is it just your typical workers' comp, or is it and how do they prove that?
Right. It could fall to workers' comp. And then how do they prove it? You're right. You'd have, if I was the only person in an employment of 50 people that came down with it, it might be hard to prove that I actually caught it at work. But if I worked at a hospital, as an example, and I worked in the COVID ward and I came down with COVID, it might be a lot easier to prove that, yes, in fact, this is work-related and rising out of in the course of my employment, I got this disease. It is a workers' comp issue. And you're right, the matter of proof, it could be difficult in some cases and perhaps not so difficult in others. Anything else?
Any other questions? Okay, thank you, Sam. Again, this is Sam Castry from Staff Management. Thank you very much. Lots of great information for our classroom participants. Just a reminder that next week, next Thursday, we will actually have 2 classrooms, one at noontime and one starting at 5:30. The first one will be local resources available in the aftermath of COVID-19. And that will be presented by Pamela Lopez from Growth Dimensions. And then we will also have an evening class, QuickBooks, and that will be presented by Vince Shirelli with the SBDC, and that starts at 5:30 p.m. So look for that information at rockfordsbdc.org. Be sure to follow us at Rockford SBDC on Instagram, Facebook, Twitter, and LinkedIn. And with that, thank you very much, everyone.
Thank you very much.
Coming up. Thank you.
Bye-bye.
Bye.